Hello, my name is Phil Seelig. I'm an attorney and senior partner at the Seelig Law Group. Today, we will be discussing Article 78. This is the procedural mechanism of suing an administrative body after receiving an unfavorable final determination from them. Now, don't let the word final concern you. Article 78 was created to remedy this very situation. Frequent examples of Article 78 are suing a pension fund for denial of benefits, compelling a government entity to take an action, suing a government employer for illegally refusing to hire you, and challenging an unjust termination by a government employer. The term Article 78 is derived from the civil practice law and rules of New York. The Article 78 proceeding is an expeditious and essentially uniform procedure for judicial review of an administrative determination. To utilize this section, you must first exhaust administrative remedies. To win, you have to prove that the respondent, the party accused of the wrongful conduct, acted capriciously, arbitrarily, or otherwise unlawfully. Our firm is currently initiating an Article 78 proceeding on behalf of a deputy chief who was denied an accidental disability benefit when the pension system claimed his trip and fall on a broken concrete sidewalk didn't constitute an accident at work. Instead, they blamed his clumsiness for his injury. We are confident that the court will agree that the pension system acted improperly and that the Article 78 proceeding will result in him receiving his justly deserved disability pension. The legislature has established a short time frame to file this action. Should you fail to file within a 4-month statute of limitations, your ability to challenge the body's previous decision can be barred forever. It is imperative that you reach out to a capable lawyer right away if you wish to file this type of petition. Most lawyers are reluctant to assume the responsibility of prosecuting an Article 78 on your behalf if contacted in the last days of this time constraint. Even if an attorney accepts your case in the 11th hour, they will often submit a rushed and less adequate argument when trying to persuade the court of the justification for a favorable ruling. The more time available to prepare a truly compelling document, the more likely you will receive a winning decision from the court. Once the petition is filed with the court and the respondent is properly served, the opposing side will then be able to answer with a defense. Each party will then prepare and submit a memorandum of law to the court. Most justices will want both sides to appear before the court and make arguments and answer questions posed by the judge. The court will want to know which legislative enactment and decisional law justifies your position. You must be ready to effectively rebut the arguments made by the opposing counsel. Some judges will rule on the day your case is heard. Others will reserve decision until a few months after the hearing. A court order will then be signed and sent to the parties. Should the court fail to accept your arguments, an unfavorable ruling may be overturned by filing an appeal with the appellate court. With a favorable ruling, the defendant is obligated to abide by the court's final order. You've won, and going to court was the right move for you and your family. Thank you for joining us for this installment of Law Matters. If you've heard anything that you would like to find out more about, or more importantly, you have a legal matter that you're ready to have an experienced and winning legal team help you with, please call us at the number on your screen, and an attorney will contact you by the next business day or sooner. Remember, when winning matters most, call the Seelig Law Group.
The Law Matters video series is provided as a public resource by the Seelig Law Group and is not legal advice, nor does it create any attorney-client relationship between the viewer and Seelig Law Offices, LLC. Always consult a licensed attorney authorized to practice in your jurisdiction regarding any of your legal matters. Remember, when winning matters most, call the Seelig Law Group